Okay, there you go. Thank you.
Well, thank you very much. Good morning, everybody. Thank you for inviting me, Lisa. I actually I've been on 10 planes in the past 8 days. So I'm a little tired. I don't have any notes, so we're gonna wing it today, okay? We're gonna wing it. But among litigators, if you walk into a courtroom with no paper, you either lost your bag or you're like incredibly smart. So let's go with the latter. And the PowerPoint is sort of at an oblique angle to me, so I'm gonna try and work through this with you. I'm gonna go over some of the very basic jurisdictional rules. Everybody in this room knows that jurisdiction is not at all easy. There are very few bright line rules. We're gonna talk about that. And we're going to talk about how domestic violence plays into that, including the so-called Alaska exception, why all of us probably on this panel completely freaked out, and then what it means when it was repealed, because it's really just 2 words that we fought over, and it's the words any person. And it totally changes the landscape of what you can do in Alaska. So with that, let's go. Is there a clicker? We can sit on this slide if you like. I'm just kidding. Thank you. She probably just handed it to me and I set it down like a crazy person. Yes, your glasses are right here. That's okay, we all know each other. So what is jurisdiction? It's the authority and the ability to enforce your laws. It means that you have the right to do what you're trying to do and that you can actually do it and get somebody to enforce it. That's really all it means. The jurisdiction that you have as a council limits what you can and cannot do as a court, as a council. There is a core of jurisdiction that's at tribal sovereignty. That's domestic relations, relations among tribal members, divorce, probate, family matters, children's cases, that kind of stuff is at the core of your jurisdiction. And that means things that are really key to your existence and survival and rights as a tribe. There are actually 3 kinds of jurisdiction. There's civil, which means money damages or injunctions to make people do things, like a court order to say you must return this child. That's civil. Criminal, which is penalties like criminal fines or prison time. And we're going to talk about how there's a couple of tribes that are actually now doing that to non-Indian perpetrators for the first time since 1981. And regulatory jurisdiction, which is like having an EPA, like an environmental protection code or whatnot. So we're going to talk mostly about civil, with just a small side trip into criminal. So I can barely see, because there's not one in front of me. So hold on one second. I'm going to pull out my paper copy because I have too many words and now they're too small. So okay. So there's a couple different kinds of jurisdiction, or where you get it. You get it, frankly, because you're tribes. That's the basic rule, because that's who you are and you have that authority. It's inherent. The first kind is inherent. And that's a recognition. So when a court calls it inherent jurisdiction, it's something that existed before the United States because you're a government. And what the principle of law is that tribes have all jurisdiction, everything, that has not been removed, divested by either Congress or the courts. So it's not as though you only have jurisdiction that is given to you. It doesn't work like that. You have everything that's not explicitly taken away. So I've been in courts many times where usually the federal government has said, the tribe has not been delegated this authority to do this. And the answer is they don't have to be. They have it unless you can point to something that says it's been taken away. That's how jurisdiction works. Delegated is additional authority granted to tribes by the federal or state government. There's one really good example, which is in a 1990 case called Duro versus Reyna. The Supreme Court said that tribes only have criminal jurisdiction over member Indians, like people that were members of their own tribe. And if you can imagine, that's not everybody in your community, because people don't always marry people within the same tribe, so your DV jurisdiction would be like 3 couples. So right after that, Congress did something called the Duro Fix, where they delegated back, basically fixing the Supreme Court case, and said, no, we're giving you back criminal jurisdiction over all other Indians, American Indians and Alaskan Natives, regardless of whether or not they're a tribal member. That's an example of delegated jurisdiction. The Supreme Court says it's not inherent, and then Congress says we're giving it back. So inherent jurisdiction is really based on sovereignty. It used to be very land-based. The courts used to basically say, where did this incident occur, whether it's civil or criminal. They don't do that anymore. They look at the membership of the people involved in the incident, whether it's child protection, divorce, lawsuit, car accident, whatever, and the kind of land that it occurred on. So there are certain kinds of jurisdiction. There's the kind that's exclusive to you, the kind that is probably exclusive to you, but not all these boundaries have been tested. So I'm giving you very general stuff. There is the kind that's concurrent. It means you share it with the state, and either they or you can bring a certain case. And then there's stuff that's probably concurrent. So we're going to skip the gray areas, and we're going to talk a little bit about exclusive to tribe. Deciding who are your members, deciding what your membership rules are, your descendancy rules, that is your business. Deciding what your laws say, that is your business. No other court can tell you those things. Those belong to you. The kind of government that you want to have, if you have a council that also acts as a court, your business, completely your prerogative to do so. That's not something an outside court can tell you what to do. That's exclusive to you. Also, if for children domiciled on a reservation, exclusive child protection jurisdiction. Mostly, of course, important in the lower 48, but, and I always say this, but I must, because there's always somebody who doesn't know. I really hate it when people say there's no Indian country in Alaska. That is totally untrue. The Venati case said that native corporation lands held in fee simple are not Indian country. There are millions and millions of acres of allotments that are restricted trust land between 5 and 8 million, and they are probably Indian country. As a matter of fact, I would totally agree with that case. You want to mention one to me? So just so people know that your jurisdiction may be impacted by a decision like that, and increased once a court states that clearly. But in terms of pure law, allotments are Indian country, and there are millions of them in Alaska. As a matter of fact, when I go to most communities and I look at your BLM or your the realty officer with a map on their wall, all those red blocks are like little reservations, and they're all right next to each other, right in the middle of the village. So that's what that is. So here are the general limits on jurisdiction. There is no criminal jurisdiction over non-natives, non-Indians, but over all natives and Indians. That's called the Duro Fix. That was a real bright line rule until recently, and we're going to talk very briefly about VAWA and how it gives a piece of that back, because they left a vacuum where tribes could not criminally prosecute DV perpetrators that were non-Indian but who were living in their communities. And so there's now a tool to help fix that. Some of the other limits are the fines and punishments are, limited. $100 is now $5,000. They changed those. So the general civil rules, so you have a pretty clear rule under criminal jurisdiction. The general civil one is jurisdiction over members and non-members who are American Indian and Alaska Native who threaten the health, safety, and welfare of the tribal community. It's called the Montana test. If you're wondering, how do I take those words and figure out whether or not I have jurisdiction over these people? There are 10,000 cases interpreting those words. It is extremely fact specific. However, I will tell you this, if it involves something domestic, violence against women, violence against children, and people are living in the community, very highly likely that you have jurisdiction over that. You absolutely do if your victim is, or your plaintiff or the people in danger are tribal members. So keep that in mind. And we're going to talk a little bit about how VAWA addresses this. I'm giving you general civil jurisdiction rules, but VAWA very explicitly says the two magic words, any person in your community. So VAWA actually gives you more than this in civil jurisdiction. And as I mentioned, because both sovereignty and jurisdiction are based on party membership, that's the first thing you're going to look at when you look at these. Okay? There are no easy tests or rules. The tribal court is more likely to have jurisdiction if members involved or actions occurred in the tribal community. Here's the key part. Make your findings really carefully. Where did it happen? Who owns the land? Is it the one parcel that the state happens to own? Or is it on one of the 77 allotments in the community? Very important to mention that. So the general rule there on the fourth bullet point is be very cautious exerting civil jurisdiction over non-natives except VAWA, which we're going to talk about, and no criminal actions can be taken against non-natives except VAWA. So anyway, I wanted you to have this baseline because it's hard to understand what VAWA did and how it changed everything until you have a real basic understanding. So the last part down here under guidelines is to be really careful, and I know folks will be talking about the technicalities of writing court orders and everything. We see, pardon me, I'm sorry about that. We see a couple of times people will send us court orders, which are forms, and they check the box, and that's fine. It's very helpful to show you what you need to include, but they won't have filled out the descriptions. They'll just check the box, imminent danger, plaintiff notified. I would strongly recommend that you make absolutely sure you have your notice, that you send it with that return receipt requested, that green card, or that you hand deliver it and have someone write down who they handed it to, the date and time and where. Have a hearing and then record your opinions in writing. So those are the way that you really sort of protect the general jurisdiction I'm describing. So let me pull up my other piece of paper because this is now way too small for me to read. Everybody get out their magnifiers. So the interesting thing about VAWA is, and we're going to go to Part E, D2. If you see that right there, this is about full faith and credit enforcement of protection orders. Now, domestic violence, obviously a huge problem all across Indian country. This bill was a reaction to that, to say, those squishy, unclear civil and criminal jurisdiction rules, we need to do something about that. How are people supposed to function with something as important as domestic violence if they have to have a lawyer analyze whether or not they have civil jurisdiction? So they set up a full faith and credit enforcement of protection order. This means that you issue your order and the troopers have to serve it, and the state has to enforce it. D2 says no prior registration or filing as prerequisite for enforcement. This is from 2000, by the way. Any protection order that is otherwise consistent with this section shall be accorded full faith and credit, notwithstanding failure to comply with any requirement that the order be registered or filed in the enforcing state or tribal jurisdiction. This was recently a big issue. If you tried to give a tribal protective order to a trooper and they said, no, you have to register it in Bethel or Fairbanks or whatever, totally untrue, and has been untrue since the year 2000. Okay, so we really do, obviously everybody up here appreciate the Attorney General's recent opinion saying they're going to register tribal court orders without enforcing them. That's been the law for a long time. It really has. So here's what happened up here in Alaska. The 2003 reauthorization happened. Now, I don't know if there's a great story behind what happened, but here's the change for tribal protection orders, right? This is section 905. For purposes of this section, which is a domestic violence protective order, a court of an Indian tribe shall have full civil jurisdiction to issue and enforce protection orders involving any person. Those are the new words. including the authority to exclude violators from Indian land and to use other appropriate mechanisms in matters arising anywhere in the Indian country of the Indian tribe or otherwise within the authority of the Indian tribe. The change from 2000 to 2013 are those three words, involving any person. So suddenly that civil jurisdiction saying don't bother with non-Indians in civil proceedings, and it's a little sketchy and a little gray. This says any person. And so those of us that saw the next slide, let me go back here. Those of us that saw this is a legal term, we freaked out because we wanted those words involving any person. But instead, there was this, Section 910, the special rule for the state of Alaska. In the state of Alaska, the amendments made by Sections 904 and 905, in other words, adding involving any person to your jurisdiction, shall only apply to the Indian country of the Metlakatla Indian community. And then there's this Part C, it's called a savings provision. And I don't understand this either, but this is the explanation I got. Let's see if any of you can figure this out. Nothing in this act or amendment diminishes the jurisdiction of the state of Alaska, any subdivision of the state of Alaska, or any Indian tribe in the state of Alaska. So they say we're not giving or taking away anything, we're preserving everything, except that we just gave folks involving any person and we're excluding you from that. And so we're taking that away, and it was a little bit of like mental gymnastics. I could not figure out, and I said, if I have to walk into a court and say that they can have domestic violence jurisdiction over any person, which of course they should, I don't know how to deal with that. And I've been a lawyer for a long time. I don't even know what that means. Usually you put a savings provision when you're saving something very clear, not when you're radically altering the jurisdiction. So anyway, it drove us completely crazy. The other thing it did was it created, now this is new, we've had since 1981 a rule all across the country that tribes have no criminal jurisdiction, the ability to imprison people who are non-natives. So you can, tribal members, members of other tribes, what are called non-member Indians. That's what Congress did in the Duro fix. This says that tribes can have this special domestic violence jurisdiction where they will have criminal authority over non-Indians to arrest them, to detain them for domestic violence purposes if that person is in an intimate partner relationship or living on the reservation. So they're trying to clearly not change the criminal rules except when it relates to domestic violence for women and children, or partner violence, basically. It could be woman to man as well. So they did this, and you have to, someone who knows more about this than me can maybe explain the technicalities of, you basically have to request it and have it be approved by the BIA. And I think there are now only 5 tribes, one of which is Cherokee, that have this special kind of jurisdiction. But it's unusual because this was since 1981, people couldn't do this. So you had this black hole of non-Indian people living in native communities, committing domestic violence, and nobody had jurisdiction over them except for the FBI, which obviously didn't get involved in DV cases very often. So this was a big deal to switch this, and there was recently one of the court cases in Cherokee Nation where they arrested and imprisoned a non-Indian man for perpetration of domestic violence against his family. It's a huge sea change in how things work. It fixes that black hole. So, but of course, for a little while, we were all exempt from any improvements, the addition of any person under civil, and totally excluded from the criminal side because of this. And so a lot of you in this room, and I'm sure Lisa, and a lot of people put a lot of work into getting this single sentence that was put in that says, Section 910 of VAWA is repealed. So there's no longer a special rule for Alaska. This right here is gone. It's no longer law. within a matter of something like 18 or 20 months, people got so upset and they repealed it. So this is the rule that you now live and operate and work under when you are considering issuing protective orders for domestic violence. Stay away orders, banishing them from the village for public safety reasons. So you have full civil jurisdiction to issue and enforce protection orders involving any person, including the authority to enforce orders through civil contempt and to exclude them. So this is expanded, it's clearer than the general civil rules I gave you about the health, safety, and general welfare. That's general civil jurisdiction. This is very specific. This is what you can do in domestic violence situations. Any person. So don't let anybody tell you, I'm not Native, I'm not a member of this tribe. If they're drunk and committing acts of domestic violence, you have authority to issue a protective order and have a trooper serve it without registering it. You can just hand it to the trooper. And so the next time one of them says, I'm sorry, I can't do that, make sure you carry a low copy of the Attorney General's opinion in your pocket, just hand it over. Because actually the Department of Public Safety requested that opinion from the AG because their troopers were confused. A lot of times they want to help, they want to serve the protective order, but they didn't know if they'd get in trouble. Now they know, absolutely not. So the Alaska exemption is gone. So one of the things just to keep in mind, and this is my last slide, as you're looking at these things, there are different ways that you issue tribal protective orders. There are emergency ones, and then there are non-emergency ones. If it's an emergency one, the kid is in the home, baby, all by himself, not being looked after, both parents have left him or are fighting, or something is going on where you need to physically remove that child. You don't need to have a hearing at 8:45 at night and get everybody in there and serve the little green cards. You take emergency custody, and then you send notice for a hearing so that you notify everybody, give them, a couple days to get themselves together. And what you're going to want to do is notify everybody involved, and that is your determination of who is involved. People who live in the house that might have custody. If the grandparents will want to take the child, you're going to want to give them notice in case they want to participate in the hearing. It's better to be more inclusive of the family in any potential new homes or temporary homes. So what you'll have to do in regular non-emergency situations is provide due process. It's really just what I described to you, a notice and an opportunity to be heard. So tell everybody you're having the hearing, give everybody a few minutes to speak. You do not have to allow lawyers to deliver oral argument. Thank God for you. Because we just talk way too long and have way too many useless words. So, but we'll be there when you need us. We'll be there. One day you'll need us and we'll be there with all of our extra words and roadblocks. And the second point that I put up here that I wanted to reinforce, you no longer have to register them with state court. You didn't have to do that before, but now the Attorney General knows, so it should be a lot easier. I should point out, that's not something we did, it's something Department of Public Safety requested, because also the Tribal Law and Order report said in there, I don't know why the state of Alaska is telling people to register and enforce, so really, it's probably a product of their work, so thank you to them. There is no specific form for a protective order. TCC has great forms, Michelle has great forms. You can absolutely use those. If you don't want to use that, or if you don't have any handy, you can't get on the net to download them or whatever you need, the things you really need to include, the names of petitioner and respondent, and these are the two key features of a protective order, an expiration date, and make sure it's not passed when you're trying to enforce it. And if it's already expired, you need to have a new hearing and explain why it's got to be re-upped. So it needs to have an expiration date, and it needs to have conditions. Where can they and can they not go? And how long is this for? I've seen some that said within the state of Alaska. That's not going to work, but you can send them out of the village. So you have to state your conditions very clearly. And here's one that's not required, but that I strongly recommend people include. an ability for them to petition to lift the conditions. Tell them if they want to lift the conditions, like I want to come back, I want to go back to my house, I want my car back, whatever it is that you've done, that they have an ability to contact the tribal court and request that. That's always a nice out if they feel like they're ready to come back, if they're ready to work, to have the order be lifted. I always recommend that people include a way out if they petition the court or the council or whichever body you have determined has authority over this. So that's what you need to include. Names of petitioner and respondent. That's the person they harmed or threatened. Is the petitioner. The respondent is the person who's the perpetrator. Expiration date and the conditions. I also recommend that you include findings. Why are you issuing this order? Well, we found the baby in the house. Both were intoxicated and holding weapons, so we took the baby. End of story. It doesn't need to be really lengthy, but a good explanation of why it happened will help. If you cannot get someone to enforce it and you need someone like me or Nick or Natasha at TCC to help you, we can take that right in, and that's so much easier. Otherwise, we actually have to get affidavits from you under penalty of perjury, sworn by the process server at the post office to get it enforced. It's better to have findings, have them signed by the court. So anyway, that's the general overview of civil jurisdiction, how VAWA is impacted, clarified, and expanded, and then the basic things that you definitely want to include. So now on to more useful information. Thank you very much. You know what? I walked up here and I'm so tired because I've been on 10 planes in the past 8 days that I completely forgot to introduce myself. So although you did a good job, so I'm Natalie Landreth from Chickasaw Nation of Oklahoma, Raccoon Clan, Imatobi family. I'm really far from home. I've worked at NARF since 2003. Call us if any of these things happen to you. Thanks very much.